This is a brief introduction to battery under UK criminal law. Much like a technical assault, battery is also a common law offence. The only thing that's defined by statute is in the Criminal Justice Act 1988, section 39, which states that it's a summary offence and people that are found guilty of this offence should be liable to a fine not exceeding level 5 or imprisonment not exceeding level 6 months. The actus reus of battery is when the defendant applies unlawful force to a victim. The mens rea is intentional recklessness in applying this force to a victim, and that's a subjective test. Just to run some clarity, unlawful force can be any form of unwanted touching, such as kissing, which was unwanted, or even touching clothing. This was seen in R.B. Thomas. Haystead v. Chief Constable of Derbyshire saw that a battery can be indirect. This was where a man punched a woman who dropped a baby, and so that battery was indirectly linked. Fagan v. Metropolitan Police Commissioner looks at whether a battery can be caused via an omission. A man ran over a policeman's foot and a policeman said, "Get off." The man didn't and remained there. This omission amounted to a battery. R.V. Brown stated that consent for battery could only be on grounds of something which was within the public interest. This was some sadomastic people who enjoyed inflicting pain on others for sexual pleasure, and the courts decided that this couldn't be sufficient enough for consent because it wasn't within the public's interest. Likewise with horseplay, this was decided in R.V. Jones, where injuries suffered through horseplay or messing around within the school playground should always be left to the jury's discretion to decide whether or not that amounts to consent.